A lot of times here at Gunderson, Denton&Peterson, we have people come in who have an issue that's related to arbitration or mediation. The first thing probably is to understand the difference between the two. Mediation is when you get two parties together and using the help of a mediator, usually a professional lawyer or some other trained professional, they try to come to an agreement between the two parties that both sides can live with. An arbitration is more like a private trial. You have a judge, usually a paid person, a retired lawyer or a retired judge, and they serve as the judge over an informal trial proceeding. There can be discovery, just like there is in normal trials. There can be every aspect of a trial that you'd normally have, except things are typically simplified. The procedures are easier and quicker and cheaper. There's usually not an appeal. And again, the judge is not paid by the state, so he's a person who gets paid by the parties, usually. Nowadays, there are a lot of contracts that have more requirements for arbitration than there used to be. For years and years, credit cards have had arbitration as one requirement of their contract. So if you ever have a dispute with your credit card company, chances are you're going to be required to go to arbitration rather than go to court. But arbitration has become a lot more popular over recent years. Nowadays we have arbitration clauses that appear in contracts for nursing homes, for doctors, for employment very commonly, for car purchases, cruise ships, all kinds of things. Arbitration is becoming more and more common, and frankly one reason is that big companies like it. Arbitrations are cheaper for a big company to participate in than a trial. They don't have to worry about having a jury there that they have to convince, who might be maybe a little bit less favorable toward the big company's perspective. Some people say for that reason that arbitrations are less fair than going to court. They say, hey, you know, if the company is choosing who the arbitrator is, that doesn't sound very fair. Or even if the arbitrator is being chosen by the same company over and over to be an arbitrator, then obviously his or her economic incentive is more toward the big company who's a repeat player rather than toward the little guy who he or she will probably only see once as an arbitrator. So those are concerns that people have, but be that as they may, the country we live in is more and more going toward arbitration and less toward trial. So it's important to understand the significant issues that relate to arbitration. One thing that plaintiffs usually can do is they can make sure that the arbitration is fair by at least making sure that the arbitrator doesn't have any specific ties to the company at issue. Another option that you can do is look for an attorney who does arbitrations frequently, so that that attorney can kind of be seen by the arbitrator as having a little bit more of a repeat player influence. The arbitrator might feel a little bit more like he or she needs to be more straightforward, more candid under those circumstances. We do have more and more arbitration than we used to, and so it's important if you find yourself in a situation where you think arbitration is something that might be in your future, you'll want to talk to an attorney who, number one, has familiarity doing arbitrations, and number two, knows enough arbitrators around town that he or she can guide you a little bit as to which direction to go, what the upsides, what the downsides are, what the costs are going to be, and really give you a full picture of what you're going to be looking at if you end up in arbitration.